Good evening, everyone. Thanks for joining us for this monthly law update for the month of May 2023. Our knowledge corner focus this month is going to be on the law of resignation. With that, we start looking at this month's update. There are not any much amendments that are there, except for a few in the Andhra Pradesh welfare rules, wherein they have brought in appellate authorities and their minimum qualification and what is the procedure to file an appeal. So these are being modified under the Andhra Pradesh Labour Welfare Fund rules 1988. They've also brought in changes to the fine in the event of contravention. So the first fine is around 25,000, and then there's a steep 4-time increase of 1 lakh. So if any kind of violation with the Labour Welfare Fund rules, the penalty amount is 1 lakh, which is quite a steep increase in the penal amount. The circulars and notifications, the government of Puducherry's notification, more to mitigate with the heat wave, we thought while the government, this is more a suggestion, it could be where many employers can proactively do changes to keeping in terms with these as a minimum guidelines, given the heat wave that we are all facing, which is a normal routine during this period of the year. Even changing hours of work, rescheduling hours of work, and various other thoughts they had. Similarly, every employer can do on their own something given the heat wave. The Provident Fund organization has given out a circular on changes that can be made by employees, and they've extended the time for making the corrections. The ESI Corporation has also issued with various circulars. These are all more as to the bringing in various areas for different benefits. For instance, in Tamil Nadu, Kanchipuram, Tirupattur, Tirunnamalai, and Viluppuram, Regulation 95A benefits for families of those who have been hurt or deceased are being extended. Similarly, in other states like Gujarat and Gandhinagar area as well, they have extended. The applicability of the ESI itself has been extended in state of Bihar to many districts which were earlier not covered. So these are certain notifications that the ESI Corporation has issued during this month. Under the Telangana Shops and Establishments Act, the government of Telangana has issued a notification on 15th of May 23. This notification pertains to running off shops 24 hours. So keeping them open all days in a year. So 365 days you could have the shops open, subject to your other conditions of 8 hours, weekly holiday, overtime when they're required to work more than the normal hours. And they also want employees to be provided with appointment letters, and they have fixed the hours of work of a shop between 9 and 11. So these are various conditions that have been imposed by the government of Telangana for permitting shops to be open 365 days in a year. Moving to our next segment, the quiz segment, a very simple question on: is fixed term employment applicable to state of Tamil Nadu? Is it, in other words, is fixed term employment permitted in Tamil Nadu? Is the question. Please do key in your answers into the chat box. We will give you the answer at the end of the session. In the across the globe segment, we are looking at an American ruling where an employee outburst or heated comments against his manager, or even in a social media, is it a good ground to terminate an employee? And the National Labour Relations Board has said no, it's permissible, and as far as it's not vulgar or anything, and it's only an outburst at that point of time out of frustration, they've said that it's fine. And in fact, they ordered reinstatement of the employee, which normally is not the norm in US. So it is quite a path-breaking judgment in American labor jurisprudence. Just a news item about in Vietnam, not of any law there, but the fact that 6,000 people could be laid off in Vietnam and without much hue and cry about it. The law there looks to be more flexible than what we have. Moving to the Knowledge Corner segment for the month, we are touching on the law of resignation. So when an employee were to give a resignation, is it open to an employer to refuse the resignation is one question that we thought we should, but we also have one withdrawal. So there are many people who are under the impression that if an employee gives his resignation, it could just be accepted and he could be asked to leave on the same day. But the law is not so in certain circumstances. So we thought we will just brush upon this topic this month. So the employee before acceptance can withdraw his resignation at any point of time. This is quite well settled legal principle. So before an employer accepts the resignation, the employee can withdraw the resignation. In this case, what has happened is the employee gave his resignation. The employer had also accepted it, but had not communicated to the employee. And the Supreme Court said, no, it's anyway been accepted. Therefore, non-communication is not a must. But then it is on the facts of that case that this judgment was given. So it is not like they were able to establish the acceptance of the resignation, but only the non-communication. But in private employment, if you were to say that I have accepted the resignation and that documentation as to how it was done could be a challenge. Therefore, please do mind that though law is good, the manner in which you will be able to establish that the resignation was accepted by the employer is something that you would need to take into consideration. Again, in this case as well, the resignation was accepted. Thereafter, the employee sought to withdraw, and the courts concluded that it will have no consequences. This is again one more recent judgment. In 2019, Supreme Court held that if standing orders provides for 30 days, employee gives his resignation, and at the end of 30 days, it's automatic. And the employee will serve the 30-day notice period and leave. There is no question of thereafter. There's no acceptance of my resignation by the employer. There's no written acceptance is not required. Is a finding here given by the Supreme Court. This is again a case of more on service law rather than labor law, where from a post, an employee gives his resignation rather under the voluntary retirement scheme. The employer also accepts it, and thereafter, the employee seeks to go back on the letter of acceptance. Supreme Court said your resignation under VRS was accepted. Your date of relieving alone was pushed to a later date, and therefore it will not in any manner say that you are continuing and you cannot withdraw it thereafter. So in this case, let me just recap the dates. Sorry, my slides are wrong with the dates. So let me just, employee submits his resignation under a VRS. Employer accepts it. Employer thereafter tells the employee, while we have accepted your VRS, we propose to relieve you only from a next date. So till that date, you can continue to work. But your resignation has been accepted. Thereafter, before the employee continues to work, but before the relieving date, the employee gives a letter saying, I want to withdraw my resignation. That's on 1st of July, and where the employer says, no, we have already relieved you. It's only we asked you to work so that we could pay your dues on a particular date and relieve you on that date. And therefore, you cannot now withdraw the resignation. Supreme Court has also upheld, saying that your acceptance under the VRS has been accepted. This is more a case of resignation under VRS. So it has been accepted. The contract has come to an end. And only for settlement of dues alone, you were asked to continue to work till they could make appropriate arrangements to settle your dues. And therefore, the question of you withdrawing will not arise, and the contract is already fructified. So this is the finding given by the Supreme Court in this case. So as I said, what happens in many cases is employee gives his resignation. And what does the resignation state is very essential. If the resignation letter states that, please relieve me with immediate effect, then it is open to the employer to either say, yes, I am accepting your request to be relieved with immediate effect. As per the terms of employment, you need to serve 1 month or 2 months of notice. I am waiving that. I don't want you to work for me for that period. I am happy to let you go today itself. That's one option. Or the employer can say, yes, you resigned. You're requested that you be relieved immediately. I, however, have to look for a replacement or arrange my affairs. So please continue till X date or till the 2-month notice period or 3-month notice period is over. So please continue till your notice period is over. So these are the two things that are possible. But if the employee doesn't say, relieve me with immediate effect, it means that the employee merely says, I hereby tender my resignation. And the word relieve me immediately doesn't find place. Or the employee gives a date saying from X date in June or X date in July, relieve me. It is not open to the employer to relieve him before that date. Such cases could be as in a wrongful termination rather than resignation being accepted. Further, on a practical aspect, always there are possibilities of threat and coercion being said. Therefore, please, when somebody tenders the resignation, space it out by 2-3 days and thereafter accept the resignation, so that even if he says threat or coercion or whatever, this 2 days was there in between, he could have always said it. So even if he takes to court saying I was threatened or to resign, this 2 days time would have been there, and therefore when you go to court, you could tell the court, yes, he resigned on Tuesday, I relieved him only on Friday or Saturday. He had in between period where he could have said that that resignation on Tuesday was not voluntary. He thereafter took my relieving letter in Friday or Saturday, and therefore it was a voluntary resignation. It's not a coerced one. So resignation also, please be sure as to how you word your leaving letters, and also what is the content of the resignation letters. And this was, we thought it's not much to do with the labor law, but we thought it was an interesting fact that came out of where a person just taking out buffet food was asked to compensate the restaurant. We thought it was quite funny to read it, and so we put it here. In the case law corner, we had actually touched upon this case earlier as well, because again and again this question comes on attendance bonus and things being considered for Provident Fund. The tribunal held in favor of the employer, single judge held in favor of the employer, and the division bench also held that the attendance bonus doesn't fall within the expression of basic wages, and therefore it is an exception to the definition of basic wages, and there's no requirement to pay contribution on attendance bonus. The next case is where the employee raises an industrial dispute challenging his employment. The Labor Court records that the management was willing to pay a compensation of 5 lakhs. and passes an award directing the management to pay 5 lakhs. The management files a writ petition stating that neither we agreed nor have we allowed our advocate to represent, saying that we are willing to pay 5 lakhs, and challenge that award by way of a writ petition. A single judge of the Madras High Court held that if that finding of the Labour Court that the management offered compensation of 5 lakhs is an incorrect finding, then you need to file a review against the award. The management filed a writ appeal against the order of the single judge. The contention of the management is that the Labour Court doesn't have power to review its own award, and it becomes functus officio. The High Court accepted this legal position and set aside the award, saying at no point of time the management had agreed to pay 5 lakhs, and held that and ultimately dismissed the dispute. Moving back to the quiz segment on fixed term employment, the standing orders in Tamil Nadu do not provide for fixed term employment. So it is a no at the moment. Many are under the impression that you can engage fixed term, while many states have amended the standing orders providing for fixed term. Tamil Nadu has not done so till now. In the Lex Posh segment, we are looking at a very, very important judgment of the Supreme Court. Supreme Court, this is again in May 23, has passed this judgment. It has referred to the fact that over the last, it's 10 years now since the Posh Act has come and has been notified, but not much has been done in this regard with the implementation. So it has asked all governments to give certain data to the Supreme Court on what they have done. They've asked ICs and LC details to be furnished. They've also asked to ensure that awareness sessions are done and the data. So many of you may be getting requests from the government or things asking you to give data on what kind of awareness programs you've done, what has been the workshops that you've done to sensitize your employees. And they may be asking on your annual reports and stuff that has happened, because they need to, government in turn has to give the data to the Supreme Court. So please be ready with these data. And if you have any queries in this regard, please feel free to reach out to the Lex Posh team, and they would be glad to help you in this regard. The last is just an upcoming program of Lex Posh on 29th May, just online sensitization program on Posh Act. The complaints calendar, we would of course be sharing this along with our PPT. We will also be uploading the PowerPoint in our website. Please do feel free to use it and refer to it at any point of time. Thank you for joining us. Looking forward to meet you on 24th June again at 4 p.m. Thank you.